Disputes in construction are inevitable. We can do everything in the book to ensure all details are covered, correct forms, procedures, and quality checks are in place. However, there are always going to be disputes that arise. Most of the time, we hope that disputes can be dealt with through proper communication between parties involved. However, this isn't always the case. Sometimes parties fail to reach an agreement. In this instance, an external body may need to be brought in to aid in finding a resolution. In this video, we'll be looking into what provisions are in place within the NEC3 and NEC4 for dispute resolution. Before we begin, be sure to like, subscribe, and hit the notification bell. The NEC is often regarded as a powerful tool in dispute avoidance, with its emphasis on regular and detailed communication. It ensures most disputes are resolved before they have a chance to escalate. But what provisions are in place for when these disputes do occur? Provisions for dispute resolution can be found under Clause W1 and W2 in the NEC3, and the new Clause W3 in the NEC4. Clause W1 and W3 are used when the HGCR Act does not apply, i.e. when works fall outside England, Wales or Scotland. NEC offers a two-stage approach to dispute resolution. The first step is adjudication. Then if the dispute still isn't resolved, either arbitration or litigation. NEC4 adds a step prior to adjudication, called senior representatives. Under this approach, each party has a senior representative who will meet and attempt to resolve the dispute before there is an adjudication. It should be noted, however, under Clause W2, use of senior representatives is not mandatory. Otherwise, it would conflict with the HGCR Act provisions, which states that any party may take a dispute to adjudication at any time. NEC4 goes even further and includes the option for a dispute avoidance board, which can be enacted under W3, another alternative for adjudication. As we're being biased, we're going to look more deeply into Clause W2 for use within England, Wales and Scotland. Clause W2 provides a process and timeline for referring a dispute to adjudication. The first step to referring an adjudication is to provide a notice to the other party. If there is a named adjudicator in the contract data, they should also receive a copy of this notice. The referring party then has 7 days from notice of adjudication to refer the dispute to the adjudicator. Both parties then have 14 days to provide the adjudicator with more information regarding the dispute, unless agreed otherwise by parties and the adjudicator. The adjudicator then has 28 days from the date which the referring party referred the dispute to the adjudicator to provide their decision and justification. This timeline can be extended up to 14 days with agreement of the referring party. Once the decision has been made, a party has 4 weeks to notify the other if it wishes to refer the dispute to a tribunal. Otherwise, the intention is that the adjudicator's decision has become final. We hope you enjoyed this video. If you want to further expand your knowledge on dispute resolution, we have another video on the topic, which we've left a link to in the description of this video. Metroun, a commercial hub to your business.